Okay, this is a 30-second warning. Mr. Ripple's in the room. Or do you need some time to set up, or you? Okay. It being 10:02, I'm going to go ahead and convene the first hearing today on 1677. This is going to turn out to be more of an informational slash working meeting. The committee won't be taking any persistent votes on this. We may want to just take a sense of where everybody's at, but that if we do that, it'll, whatever process we use will be informal. So I guess the gavel makes it official, but do we have somebody here from the Child U.S. Advocacy, Child USA organization? Two people just stood up, three people stood up. Are those yeses? So I'm going to just try it one more time. Is there anyone here from the Child U.S. Advocacy or Child USA organization? We've received written testimony, and I'd like to extend you an opportunity to speak to your testimony. Okay. Seeing no one moving, let's bring up the AG and his dynamic duo.
Thank you, Representative Edwards and members of the committee. Good morning. Just for the record, John Formella, Attorney General. Over the past couple weeks since the last work session, we've really made an effort to have discussions with stakeholders, have discussions with plaintiffs' counsel, and the results of those discussions were the proposed or potential edits that we submitted earlier this week that I think have been distributed to all of you. To my right, as before, is Senior Assistant Attorney General now, Jen Ramsey. Just as a quick aside, I just want to make everyone aware, Jen was just promoted earlier this week to Senior Assistant Attorney General, so that reflects the excellent work she's doing for the office.
So that reflects more than just a senior moment.
Yes.
Okay.
So Jen has been instrumental in leading the effort to put some of these proposed revisions down on paper. So I'm going to have her take the lead on at least initially walking you through these revisions, but we'll both be here to answer questions. She and I have discussed these extensively, so we're both familiar with them. But as the primary drafter, I wanted to give Jen the opportunity to walk you through these. So I will turn it over for the moment to Senior Assistant Attorney General Jennifer Ramsey.
Thank you, Ms. Ramsey, and or Mr. Attorney General, and Ms. Ramsey. We do have the documents in front of us, and so, but I don't think these are viewable by the public. So just to get it on the record, if you could touch upon each one, but because I'd like to keep this to 30 to 45 minutes, if you could just be judicious about how much time you spend on each one. Obviously, if it's a minor thing, just let us know. If it's a major thought process, we'd like to understand that.
That sounds great. So for the record, Jennifer Ramsey. I think everybody has a document that says Summary of Recommendations for Amendment at the top of it. I would like to try to take them, instead of in the order on that document, just to take them instead in the order that they appear in the language of the bill, if that would be helpful.
I may be the only one, but it would be more helpful by a factor of 8 if we were to go down your summary document, and then if we and then just even if we're jumping around in the document, just because we're also going to be putting timestamps. Our clerk is going to be using your summary sheet as a way to have our minutes taken, and we're going to timestamp the meeting instead of taking document notes.
I'm happy to do it that way as well. Just grabbing the other document. So if we start then with the first item on the summary is one of the things that we did after input was we talked about this last session. We expanded the right to know coverage to include settlement agreements not being a part of the confidentiality of the documents of the YDC settlement fund. We also included in this latest draft of the bill a typographical error, I think, that was also the subject of a previous amendment. And then we, on the recommendation and input of a lot of members in the victim advocate community, have strengthened the language in the statement of purpose. We're no longer reflecting that abuse may have occurred. We're reflecting that we are investigating abuse, and we've included a statement that that we want to acknowledge that.
If I could just ask you to slow down a little bit, because in your 40 seconds, you just went through 3 things on 3 different pages, and I want people to be able to see what the change is.
Okay.
So if you could pace us through as we look at your document and look at the amendment, please.
Okay. So the language I was just referring to is on page 1. It's item number 1.
Thank you.
And you strengthen the purpose statement in what way? Would you just talk to the add-on here?
Sure. So you'll see in line 2 that we removed the language "which may have occurred," and that's because of some feedback that we received from the advocates community that language might be offensive to victims. We are referring to this as an investigation into abuse, and we've also added a statement acknowledging the claims and what the victims have been through.
All right, that's clear to me. Thank you.
Sure. Okay, next, if we move to language on page 4, lines 22 through 26.
Okay, explain what we're doing here.
Yep, you'll see that we have created an affirmative obligation of confidentiality on the part of the administrator of the fund. The claimant is not bound by that and can speak freely, but to the extent that the claimant wishes to have the information remain private, this would create an obligation on the administrator to do that.
Thank you. I understand that. If there are questions as we go, get my attention, because while the topic is fresh in everyone's mind, we can address it. But so far, I think we're all tracking. Or do you have something, Representative Irf?
I am tracking, but I just want to be clear that the summary recommendations for amendment no longer has the correct line number references. Is that an accurate statement?
If you have a version that was generated by the Legislative Services Group, I don't have that version, so that may be the reason for the differences.
It does look like they're adding numbers to me.
Well, we received something just this morning that has a number 4 in a circle next to line 24. And line 24 begins G, claims and all documents, which I think is what you were just talking about. Are you looking at the same thing?
I'm looking at the same language you are, but my document is numbered differently.
So who can you, where's the variation coming from here?
I don't know.
Mr. Chairman.
Representative Long.
Thank you, Mr. Chairman. The copies you received are my notes. So the circled numbers is my notes from the recommendations, and I also wrote my notes in there. So the circled numbers are what I referenced as the recommendations.
Well, it looks like you reformatted the document too. They're different lines.
So I appreciate you letting us use your document, Representative Long. I've been finding it useful. So I I think if we can get into the right neighborhood, and so we at least see the language and we're tracking with what Ms. Ramsey is saying, we should not be too worried about the line numbers at this point because we're gonna run this back through OLS. Which version?
If it makes a difference. This is the one that you had emailed the other day.
Right, so I think we're all looking at that.
I think so too. It's just some have a version with
And
the
then,
looks on it.
and then I asked for Pat Long's notes to get Xeroxed, because
Oh, alright.
he had red and yellows.
Oh,
and-
I see.
And it just made it easier to track, I
Okay,
think.
okay.
So, I think if we are trying to understand intent, we ought to be able to do that. So Representative Erf plays a vital role on Division III Finance of making sure that all of the debits and credits are lined up properly. So are you okay, ready to roll? Okay.
So was there a question about that section or just the,
No, I think the general question was just curiosity by the representative on how we should be using and viewing these documents. My main concern is that we are able to understand what the AG's office was thinking and that we're able to correlate that to the written word. So, and I think you're doing that.
thank you. So should we move on to number 5?
Mr. Chairman?
Wait, Representative Walz?
Yeah, can I just ask the AG to slow down just a little? You guys have been working with this every single day. You're intimately aware of it. We're playing catch up. I'm trying to read this, and you're going faster than we can read and absorb it. So
Okay.
just slow it down just a little so we actually have time to read it before you move on, if you don't mind, please.
Yep, I'm happy to do that.
Thank you.
We're slowly ready when you are.
Okay. If we're ready, number 5 should be a quick one. Page 3, lines 28 to 29. We just changed the date of the ending of the claim filing window. So it was previously a 1-year period, and now it's a 2-year period.
Thank you. Yes, Representative Mooney.
If you wouldn't mind, I have a question on that, if
Go-
that's
okay.
okay. Thank you, and thank you for your presentation, your emails. I thought the materials were very clear, so thank you. My question on moving that date, what are the pros and the cons of a 1-year versus a 2-year window, or vice versa? I find that section particularly to be very critical.
And do you have a thinking that one or the other is preferable?
It would seem to me that in 1 year, it would be managed, I guess, more reasonably, as opposed to over 2 years' time. Perhaps things might get lost in the shuffle and not be as tight as they would be in a 1-year window.
Okay, thank you for that. The reason that we expanded it was based on feedback at the last working session, that there were also folks that felt that 1 year would be too short of a time period, that because this is a process for people to have the courage to sort of come forward with these types of allegations, that we needed to give more time for people to come forward and not rush them through the process. But I understand what you're saying as well.
So let's use this as a teaching point for a second. Last meeting that you were here, you received a lot of feedback from representatives, and so you've gone away, you've consulted with the plaintiffs' attorneys where possible, and you've applied your own independent thought. So on this particular point, what I assume happened was it had been 1 year. You heard that maybe 2 years is better. Regardless of what you heard, it got you thinking. And in your independent judgment, you think the 2-year window is superior to a 1-year window. I'm assuming that this document doesn't just represent what we said, but this represents your professional independent judgment on the right way to go.
I think you've stated it well.
All
Yeah,
right.
that's correct.
Okay, thank
Yeah.
you.
And there were, to add to that, there were people that thought it should be much longer. And after giving it more consideration, we thought 2 years was a good recommendation. Item 6 is that we recommended to lift the 1980 date restriction for claims. Again, we rethought that after feedback at the last work session. The initial date recommendation that claims would not be for incidents occurring prior to 1980 was based on the Attorney General's general sense of the where the most of the claimant's claims lie. And we have since been persuaded that there may be claims that lie in earlier dates, and that it makes good sense to include those claims in the bill as well.
So your intent is just to open this up to anybody, anytime?
Correct, with the language in the bill still being that administrators of estates cannot file claims. So there will be some, as a practical matter, limitation on people that are still living. But other than that, anybody who has a claim of this type that was ever at the YDC or one of the other facilities would be entitled to participate in this process.
All right, thank you. Wait, question?
That's
Your
okay.
mask is fine, but if you would turn on your mic and speak directly into the mic. We have people out there like Representative Rogers, I believe, who are trying to follow and, yeah. So directly into the mic, please. Get it close to you.
I'm getting caught up.
And
Mr.
we were-
Mr. Ripple, would you help him with the mic? I'd really like it clear.
I'm not sure. Do you still have a question?
No, just one page. I'm just trying to catch up where we're at.
And we were talking about language on page 1 at lines 25 to 26.
So do you have a question, or are you okay? All right, no sweat. Representative Walls?
I think Representative Hatch still needs a red line copy of this. He doesn't have that, and I don't know who has them around here. You got an extra right there?
We're leveraging Representative Long's homework.
Pardon me?
We're leveraging Representative Long's homework. This is his document. It's got his notes and markups on it. No problem. There's no reason to proceed if we're not learning something, so. What number are you on now? 7?
I think we're on to 7, which is at page 2, lines 12 through 15. And again, in response to feedback we received, we determined that it was a good idea to expand the facilities that people resided in to include institutions that may have pre-existed YDC but performed the same function.
Okay, I have a question about that. I can see what you're trying to include. I just want to make sure I know that we're excluding things. Like, for example, somebody placed in a foster home, would they qualify or not?
No, because they are not in a facility that housed adjudicated youth or detained youth awaiting adjudication.
Thank you.
Mr. Chairman.
Question by Representative Long.
Thank you, Mr. Chairman. With respect to 7, would that be only juvenile petitions that had a petition against them? Is that clear? Is that a clarifier?
That would be my understanding, that they would not be at the facility unless they were either being detained prior to
Okay.
adjudication or had been adjudicated.
Great, thank you.
Moving on to number 8. On page 2, lines 4 and 5. You'll see we've clarified the definition of sexual abuse, and that's because in our research we determined that under the applicable case law in prosecuting criminal claims, that coercion can actually be a requirement under the relevant criminal statutes that we identified as a part of the definition of sexual abuse. So even though a victim, even though consent is not a defense to the crime, it still requires an element of coercion to prosecute someone. They have to have taken some affirmative act to try to coerce the victim into participating. We didn't think it was appropriate to do that in this context. We feel that there is no situation in which a staff member should ever have been having sexual contact with a victim, even if there was consent and even in the absence of an affirmative act. So that's the reason that we clarified the definition.
So even if the victim is above the age of consent and the allegation is the entire act was consensual, this is intended to say, no, there is no consent regardless of the victim's age.
You are correct.
Question?
Yeah, I guess I really have a question. I went back and read Foss this morning, and I also looked at the statute and the law. I mean, the statute has been changed a little bit, but with regard to the element of an affirmative act, that's still in the law. And I guess the thing that concerns me a little bit is the statute specifically talks, the criminal statute specifically talks about an affirmative act being required even in this circumstance and even with a juvenile. So I guess I'm really troubled by the idea of why would we make the state liable to pay compensation for something that's not a violation of the statute?
So I would give you two answers to that. First is the fact that looking for that affirmative act seems appropriate when we are talking about taking someone's liberty away and prosecuting someone criminally. Whereas we're using a criminal definition, but this is really about civil liability. So the second answer, which is really just an example of why, is you can imagine a situation, unfortunately, where a victim would actually believe that that they were going to have a relationship with a guard when they graduated from this facility, right? And so there might be no coercion, or there might be something that doesn't really satisfy the criminal definition of coercion. If that person is telling someone that they really like them, that they want to marry them when they get out. I don't think that would qualify as coercion under FOSS, but that I think should qualify as a claim under this statute.
May I ask you a follow-up?
Follow up?
Yeah, so I mean, can you tell me, this is something I didn't do, but is there a body, an established body of case law in the civil context that says someone can be held liable in these circumstances without coercion? Because I guess what I'm concerned about is if there is, then maybe that's one thing. If there isn't, would the legislature in some sense be establishing a precedent for other cases to say, the common law of New Hampshire as sort of supported by the legislature is that you don't need that?
I understand your concern. I would refer you then to the cases that we provided several sessions back in the settlement and verdict research, where you'll see quite a number of cases that have been settled and the verdicts rendered, and the kind of the view as to what constitutes sexual abuse in the context of this civil litigation arena.
Okay, and do those support the view that you don't need an affirmative act?
There are very few verdicts. There are mostly settlements, and the groups are not being parsed by whether or not there was any coercion. That just seems to be the view in those cases, that if there is sexual activity between a staff member and an inmate for any reason, even if it's consensual, and even if the staff member actually believes that they're going to marry this child after they leave the facility, that still qualifies as something that needs to be compensated.
Okay.
Follow up, or are you okay?
No,
Go ahead, Representative Walls.
Isn't it true that there can be no consent from somebody incarcerated, be it a child or an adult, if there's a sexual act there? That because of the power dynamic, because somebody's being guarded and somebody's an inmate, there can be no consent?
Right, and that's the concept that we're trying to capture with the language that we've included in this proposed amendment for you. And the anomaly is just that under the criminal law, there is some case law out there that even though that is accurate and consent is not a defense in a case of the power disparity that you just described, there is nevertheless, in order to incarcerate someone, a requirement that the defendant needs to have done something affirmative to cause the contact. and what constitutes coercion under the case law under Foss gets into a murky area that we didn't think we wanted to deal with in trying to adjudicate these claims.
Follow up, are you okay? Representative Lynn?
In light of the question that was asked, I mean, if my understanding is that Foss specifically dealt with the issue that Representative Walsh raised, that even the statute says consent under these circumstances cannot be given, but the court specifically said that's not enough to meet the requirements of the criminal law. And if I understood what you said in response to an earlier question, I think you're saying that there is no developed body of case law in the civil area that says you don't need some affirmative act. You say there's a number of cases that have been settled, but you haven't said that there's some established body of case law that says you don't need an affirmative act.
So I haven't gone and researched exactly the way you're phrasing this. We can certainly go back and look and then address that further. Where we are right now is just based on what I had previously described.
Thank you.
Sure.
So let me summarize that in layman language.
Sure.
I'm not an attorney. Fascinating conversation. We're not the judiciary. We're a finance committee, okay? And so while I completely understand and am sympathetic to the notion that an incarcerated individual is unable to consent, just the consent is off the table. I am concerned that if this is the first legislative act establishing it in our statutes, that for all civil procedures, this precedent would hold because we're passing a law, I'm uncomfortable with that. I think that would be something that would need to run through the judiciary, for example. And so I do appreciate you saying you're going to research this and do some homework. If you could maybe offline stay in touch with Representative Lynn. Again, I defer to your professional judgment. I just wanted to let you know. I think we're better staying in our lane, and our lane is not creating new judicial precedent for civil procedure.
I appreciate that, and I think we could probably address that as well by making clear that nothing about the administration of this claims process is to be taken as a precedent for other litigation purposes.
Representative Walsh?
Attorney General Ramsey just said what I was going to basically reinforce, and that is, this is a very narrow thing in the statute limited to this system, and it is not precedent for other civil cases out there. It's very clear that it's a limited situation where coercion would not be required.
You okay?
Well, I mean, I guess then the question would become why? Why is it appropriate in this case as opposed to any other case? I mean, suppose that there's, a case, suppose we have a new facility, we replaced the Sununu Center with a new facility a couple of years from now, and something like this happens. Is the law, what would be the reason for saying that, the law shouldn't be as it now would be under this case? I'm just concerned about, why are we carving out please don't misunderstand me. I'm very sympathetic to victims that were abused, but why are we carving out a special circumstance for this case?
Sure, no, and it's a great question. I think that if we were to make clear that this was not to be automatically taken as precedent for future litigation purposes, that's not going to preclude lawyers from arguing that for the same reasons we decided to do it here, they might want to, the courts might want to expand the law or might want to apply it, but I wouldn't want it to be taken as an automatic expansion of the law. I would want the judiciary to be able to consider that in the fullness of a developed record in an individual case.
Thank you.
I think we're ready to go to the next point.
Yeah. Yeah, okay, I think we've made it up to,
9?
number 9, yeah, which is, which you'll find at page 3, lines 7 through 14. So again, in response to concerns raised, we've considered whether the just notice within the state and just in the old traditional way of publication in a newspaper locally would be sufficient notice. And on consideration, we've expanded the notice requirements to include at least one national publication and within the administrator's discretion to publish in social media outlets. Again, we had requests to consider doing much more than that, but I looked into the expense and what would be involved in some of those things, and our judgment was that the best thing to do would be to leave it to the administrator to make those decisions rather than tie the administrator's hands regarding, for example, using YouTube or Twitter or all of the various platforms that were suggested to us. Those are significantly cost prohibitive in some cases, and I would want the administrator to make the determination whether or not that the expense was justified.
So this causes me to jump ahead, and you're going to recommend, I believe, the creation of an administrator to just manage the whole program. Is it in that, I'm not there yet, is it in the administrator's charge to act as a fiduciary and manage administrative costs wisely? Is that part of their accountability, or are they going to have a sort of a built-in incentive to advertise and spend tons of money just because they can't be wrong if they do that?
Right, so there's a tension there, but the reason for the move to a more independent administration was concerns that victims needed to feel protected in this process in order to participate. So the guardrails on the administrator's expenses, if you will, is that the administrator will be making annual reports to the legislature, which will include information about the expenses that have been incurred and that are anticipated to be incurred. We would anticipate also that in the search for and selection of an administrator, that the Attorney General's office would be involved and would be making sure that the billing process that would happen by the administrator would be something where the state's interests would be protected.
All right. On the list of 100 things we need to worry about with this program, this is like in the 90s. So I don't mind if there's some cautious overspending to get the word out, because getting the word out is critical to this program and the perception that it's fair. I just want to make sure that we're not creating a bad incentive to just grossly overspend.
Right, and we share that concern.
So first Representative Walz and then Representative Lynn.
Thank you. Is there a national database out there where we can input the former residents of these institutions and find out if they are incarcerated somewhere outside the state of New Hampshire, so that either the state or even the plaintiff's attorneys could have access to that information and could reach out to those potential victims, even though they're currently incarcerated or on parole or probation outside the state of New Hampshire?
I believe law enforcement has access to a database like that. I don't, on the civil side, we do not have access to something like that.
Could we do something to make that kind of access to the administrator, to somebody, for purposes of informing these victims of what their rights are?
We can certainly look into that. We had not included a suggestion that notice would go out to every former resident of the facility, because that would be an enormous process to try to locate those individuals. But the idea that we might just locate people that are currently incarcerated in other states is something we can look into.
Representative Lynn?
Yeah, I have, this is probably the area that I have the greatest concern from changing the original proposal. And I guess I have several concerns. Just to start from the beginning, I mean, it strikes me that, at least as I anticipated, and correct me if I'm wrong, under the original proposal, the administrator would be either the Attorney General or someone that the Attorney General designated within his office.
Correct.
Under this, it would be an attorney in private practice. And so I guess in terms of the cost, I mean, just at, at the initial level, my suspicion would be that if, let's assume that this process went on for, a period of 3 or 4 or 5 years, that the difference in cost between what somebody, even a senior person in the Attorney General's office, would be paid over 5 years and what a lawyer in private practice would be paid over 5 years would be very, very significant.
So let me ask, are we effectively on line 10 now because of the way the conversation's matured?
Yes, I think 10, 11, we can talk about together and are sort of a part of this
So
conversation.
I'd like you to go ahead and address Representative Lynn's question. Our clerk is using your summary sheet to keep track of where we're at for the minutes, so.
Okay, I'm sorry.
No, you're great.
That's, I guess the only thing I would say is.
I am so honored to have you on this committee. You do whatever you want and we'll adapt.
Well, no, you know what, the only reason I said this is just so to avoid confusion, because in item 10, you mentioned, I think correctly, that the change to the change in the way the administrator operates goes throughout the statute. It's not just in 1 or 2 places, it really goes kind of throughout the statute.
That's right.
And so I was raising just, the first concern I had is simply a money concern, that it seems that if we're gonna get, and I assume everyone would agree, claimants, the Attorney General's office, all of us would agree, that if we were gonna select an outside attorney, we would want a very competent, experienced, well thought of attorney to do this. And it strikes me that to get someone in private practice that meets those qualifications and determine what you're likely to have to pay that person is a lot more than what you would likely pay someone who was working in the Attorney General's office, even if the person was a very senior, well-qualified, fair, impartial, et cetera, person in the Attorney General's office.
Right. I feel the same way that you do about this revision is going to increase the cost of administration. And the trade-off or the balance is trying to have an independent administrator, but also trying to control those costs, which is why the Attorney General's office is not completely out of the process. When we get to items 10 and 11, or if we're there now, the idea is for the Attorney General to try to resolve the claims directly with the claimant, and then if the claimant is not satisfied, that the process would then move into an administrator's kind of resolution proceeding. But in that way, we would hope to keep the costs down still. I've also inquired, we had actually thought maybe a retired judge or a mediator would also be a good candidate for this. In my experience, working with receiverships, which also involve a claim process, that the claim, the work that is done does not get billed typically at a lawyer's rate for litigation. It's typically somewhat less because you do not have the overhead that you have with maintaining a law office. So I wouldn't expect typical litigators' rates, but I agree with you. This is going to increase the cost by having an independent administrator, but we felt it was necessary in order to give claimants a level of comfort that they would actually use the process.
May I ask
Go ahead, follow up.
So did you have any discussion or was any thought given to the idea of possibly amending the proposed legislation to say that, an administrator will be hired to do just this work, but will be employed in the Attorney General's office or maybe some other agency of state government, you know, at a determined salary as opposed to, you know, getting bills for even at a discounted rate, I suspect it would be.
I think the Attorney General would like to pipe in on that one.
Sure.
Yeah, I think the answer would be we didn't discuss that specifically, but that goes to something I wanted to just add into Attorney Ramsey's response. I mean, my thought is this: if we were to go this route and look to select an independent administrator, we would consider those types of options. It would not be my intent to immediately default to hiring someone who would then bill us hourly over and over again and really jack up the administration costs. So I think the language as this is written would potentially allow for something like that, but I think that's something we could think about because I agree with your concerns about expenses. I think the idea is we want someone more independent, but we don't want to hire a consultant or a consultant firm that has the administrator in it that is then going to bill us at exorbitant rates. And trust me, I'm very sensitive to that because I deal with that on all of the matters the office deals with, and that's something we're always thinking about. And we make very strong efforts to get better deals and better rates because we're just a larger client and we're also state government and not some large private corporation.
Sure.
So it'll absolutely be top of our mind. And I think that type of discussion is one we could have around this concept of trying to preserve independence but also keep costs down.
May I ask another follow-up?
Yes, sir.
This goes to the idea of the administrator. The two things that kind of concern me about this system that you're talking about here is, in contrast to the original proposal, if I understand correctly here, the administrator would be there would be one administrator who would be the final say for all the cases. Whereas under the original proposal, the final say, if the claimant didn't like what the administrator did, the final say would be with an arbitrator, and the arbitrator might or might not, probably would not be the same in all the cases. So that, I mean, it seems to me that's a pretty big difference because it may, which I suppose could have various implications. But I wonder if you could talk to why it makes sense to have, one person be the final voice without an appeal for all the cases.
Yep. Yeah, I'll start, and then I definitely want to then pass it over to Attorney Ramsey so I don't miss anything. But I think there's a couple issues there. The first is the way this is set up is even though the administrator would be independent and there'd be one administrator, it's still kind of a similar process to what we had before, and that there would be an initial chance for the AG designee and the claimant to interact and for the AG designee to present a view of the claim and what they thought the claim should be valued at. And the claimant could agree to that. If the claimant doesn't agree, as the language now says, the administrator would schedule a resolution process, and that's when you would really go before the administrator, and the administrator would make a binding decision. So on that issue, I think the process is still fairly similar, but what you have is a more independent administrator who's taking in the claims and running the process. The AG designee would still have an initial opportunity to try to resolve the claim before you went before the administrator. To your second point, which I think is a good one, and it is something I've thought about, there is a big difference between this version and the previous version, because I think you're right. If something were submitted to arbitration, you're not guaranteed to always have the same arbitrator, and that presents, I think, additional risk to a claimant and perhaps lessens the incentive to go to arbitration. It also presents additional risk, I think, to the state, because there are factors to consider on both sides there. And one factor I think about is that if we have one administrator who's independent, who's becomes very familiar with this process, who's very familiar with the guidelines, who we would, on the front end, make sure, at least from our perspective, has an outlook about this entire process that makes sense. I think you could argue, and I've been persuaded that that actually might provide more certainty that the outcome is fair. There could be a worry that if claims that went to arbitration went to a different arbitrator every time, you'd have results that could really deviate from one another. They might be within the guidelines that we establish, but one arbitrator, might look at things differently, from another. So I think there are some risks to it, but I think there are also potential benefits. And when we balance all of that with what I think is the major benefit to persuading victims to participate, and that is the independence and their feeling that they'll get a fair shake. We thought about all of that when deciding to at least put this change forward as something we thought we could recommend. I want to make sure I didn't miss anything, so I do want to pass it over to Jen.
I think the only thing I would add is that if you have, when you think about the cost of the administrator as compared to the cost of a number of different arbitrators, it's an incremental difference, but it's not as large of a difference as it might otherwise be.
No, I think you make very valid points. I mean, that's why we have, we established a business court. We're talking about possibly establishing a land use docket, so they have one. I mean, those are very valid points. May I ask just one
Yes,
other
sir.
follow-up? The last point I had is, as I understand the way this is structured, I'm concerned that the administrator, if I understand it, would know under this procedure. In other words, if the Attorney General and the claimant were not able to come to an agreement, the administrator, as I understand it, and correct me if I'm wrong, the administrator would know at the time the administrator got the case to decide what the last offer was from the Attorney General and what the last offer, what each party's position was on each side of the issue at the time the administrator got to decide the case. And I'm a little concerned that as a practical matter, that probably cabins the administrator. I mean, it would be, that's the reason generally settlement discussions are not allowed to be introduced in a trial. And so is there, could this be structured in a way that the administrator would not know that information?
I think it certainly could. That's not something I think we had contemplated, that the administrator would necessarily know that what the last offer had been. I think we had intended to structure it that the claimant could decide that it was happy with what the Attorney General designee valued the claim at, in which case the parties would tell the administrator that they'd agreed to an award and that the administrator didn't need to give any further attention to the claim. Or if not, then the claimant would ask for an administrator resolution proceeding. So
Okay, so you wouldn't have any problem then if the language was toyed with a little bit so that it would be clear that the administrator in that circumstances couldn't know what either side's position was on dollars, so to speak, would just know that they hadn't come to an agreement.
right, no, I would have no issue with that.
Are you done, Representative Blunt? Representative Emery?
Thank you. As we're talking about money, it occurred to me that later on, there's guidelines for maximum fees for the attorney, plaintiff's attorney. At what point does it jump from 25% to 33 and a third percent? Let me just put a more rounded question on that.
Yeah.
If it's to the attorney's advantage to go to the administrator where the 33 and a third kicks in as opposed to the 25, then the administrator's going to be very busy if money is a motivator. I haven't read all this changes to know, when does that kick in, the different rates?
Yep. Yep, I think you're correct that it would jump to the 33 and a third percent if it moved from a resolution with the Attorney General to a resolution with the administrator. And I think it's a good question. I think if it goes to a resolution proceeding, though, that attorney is going to need to do additional work to participate in that proceeding, and so would be making those decisions that you just described in light of the fee may get bigger, but he's rolling the dice that would the award get bigger, I might do better, I might not do as well as what the Attorney General's office has offered. So I don't think just the incentive of possibly getting a larger fee alone would be the only reason that someone would choose to move to a resolution proceeding.
But it could be, right? Because we're going to make the settlement fund award and release document in some form publicly available. And so the plaintiff attorneys are going to develop rapidly a track record on the generosity or parsimony of the administrator. So I talked to the Attorney General about this. I'm just trying to make sure that our incentive system is right. We want them to settle sooner to make sure as long as we're taking care of the justice part of it. But I don't want to create a casino environment where they go gaming the system.
Right. And I think we've tried to capture that with the way that we have structured it, and we can certainly continue to look at that.
Thank you. And then as Representative Lynn was talking, I was putting on my old manpower analysis hat, and I was trying to think through the way that we can imagine the workload hitting the administrator. And I imagine the workload will be relatively high pretty quickly, and then it will peak probably within the first 6 months to 12 months, and then it's going to start to have a tail. And that tail, by this, is expected to potentially be 10 years, right? I think if I understand it right. So what, I don't know if I really have a question in here as much as I just have a curiosity is if there gets to be a point where the natural workload seems to have been done at the 3-year point or something like that, do we have an off-ramp to excuse the administrator short of for cause? Or do we need one? Maybe that's really the first question for you is, do we need an off-ramp, or are we going to keep an administrator for 10 years?
Yeah, so it's an interesting thought. The current structure is that the administrator would be reporting regularly to the legislature, and that there's provision that the administrator could wrap this up sooner than 10 years if the workflow did what you just suggested. We'll have the claims window will close after some period of time, so the universe of claims that need to be dealt with will become finite, and they will be making predictions to you about how many are left to be resolved. So at some point, you could naturally look at this and say, I think we should move the lapse date up and dismiss the administrator, and that would be a minor legislative act, I would think.
Okay, so you're saying that you believe that the discretion is completely in the hands of the legislature to terminate the relationship, or are you saying the administrator needs to make a motion or something to terminate, or where does that discretion lie?
So I don't think we have language in the bill right now that would address that specifically, and I think the Attorney General may have some comments.
Yeah, thank you, Representative. And I know we discussed this earlier in the week. Yeah, the bill right now doesn't provide a mechanism for removing the administrator in whatever circumstances you may want to remove them under. I think we do need to think about that because I think we would all hope that this process would go well, but there's any reason why you might want to remove a state official, for example, and there are processes to do that. I think that is something we need to think about, is what mechanisms would we provide for removal of the administrator under various circumstances that we could imagine which you might want to remove them. I think then, to your point, what mechanisms are there to end the process when there's no longer a need for it? I think the bill contemplates just that the process would end naturally when all the claims have been disposed of, but we can think about that as well. I'm not as concerned about the second point as I am about the first, which I think is something we do need to think about. There's really no state official or anyone appointed under state law who can remain in their position forever, and regardless of what happens, or whether they commit malfeasance, or whether there's cause to remove them. So I think we need to think about that.
Thank you. I want to do a sidebar real quick. Representative Umberger, would you remind me when this group needs to be done with what it wants to recommend to the full finance committee?
Yes.
Do you need a
It-
moment to think about
No,
that?
No, it has to be reported out not later than the 10th of March.
Okay, so, Mr. Attorney General, you and Attorney Ramsey are talking about going back and doing some thinking deeper on a few things. How are you feeling about the amount of time required to do that properly?
I am confident that we can. So I guess it depends on where we end today and what we think the full scope of the issues are that we still need to address. But I have been aware of the March 10th timeline this entire time, and it's been, I've been thinking about it. I'm confident that we can think about whatever issues are presented and come back to you with proposed language with plenty of time for you to consider it and get the bill to a point where it could be reported out by March 10th, if that's ultimately where you get to.
Okay, thank you. So when last we looked at the summary, I think we had just knocked out 10 and 11, and we're about to enter 12.
Yep, and number 12 is language that appears on page 3 at the bottom, continue on to the top of page 4. And again, this is just some language to strengthen the perception on the behalf of claimants that this is a process they can choose to participate in but are not required to. And then, again, strengthening that to make sure that they understand the decision that they're making and entering into this process, that we would make sure they understood that they had a right to consult with an attorney, since we are asking them to commit to this process with a waiver of rights to continue in litigation as a part of their determination to participate in this program.
Looks good. Right?
The next item is on page 7 at lines 1 through 10. We had some further thinking about how the administrator might utilize installment payments in resolving claims, and wanted to make clear that would be something about which the claimant would primarily get to decide, and only in the case of a claimant who wished to receive periodic payments or a situation that was so clearly warranted that kind of treatment that would be the only circumstance in which that would be utilized.
Representative Lynn?
So yeah, I think, I agree with sort of the first part of that. It seems to me that it does make, a claimant should, if you decide, if the state is going to pay somebody, the claimant should decide whether they get it in installments or not. I guess I'm a little bit, the last part of it, a compelling need to protect the interests of the claimant. I guess that has a little bit of the sort of nanny state part to it, and I'm wondering, if the claimant and the claimant's who's represented by counsel say, we want the money right now, the whole thing, and the claimant's competent, what's the basis, to say, well, you're really not very responsible, you're going to blow it all in a year, so we're not giving it to you.
So, yep, I understand the concern. It is an exercise a little bit in paternalism. It is limited to large awards, and it certainly is not something that has to be included, but we thought it would be something that you might want to consider doing, since there is a fair amount of information out there in the literature that sometimes receiving an enormous amount of money right up front can actually be harmful to a victim. It can have believe it or not, it can have all kinds of traumatic effects on the individual to suddenly receive that kind of an amount of money.
That's good.
Sure, I'd even say professional athletes have that problem. And they're supposed to be competent. So go ahead, Representative Lynn.
So
Follow.
I'm wondering, would it make sense to put something more specific into what the administrator would have to find to be able to, because I mean, again, it just, what the, it just seems to me to be pretty distasteful for an administrator to be able to say, with a competent claimant represented by competent counsel who say, we want the money now, for the administrator to say, what, you're not responsible enough, or your lifestyle demonstrates that you're not responsible enough to get the money. I agree with you on the sports figures, but they do get them. They do get the money and are allowed to blow it.
Right, 75% blow it. So,
Yeah.
Representative Erf, do you question?
Would you mind if I respond to this?
Go ahead.
Yeah, so I definitely see the concern, and we're wrestling with it. There's a couple issues I just wanted to point out. One, we certainly don't want to be paternalistic, and we certainly don't want to not have respect for the victims. I do think it's important to remember that many of these victims are individuals who have suffered a lot in their life, not just from abuse they may have suffered at YDC, but they may have suffered before that. They may have had really tough times since that. Whether we want the administrator to be making, competency determinations as you might make in the criminal process, I'd be reluctant to have that. But I think that it makes sense for an administrator who is dealing with individuals who may be dealing with a lot. Some are maybe incarcerated, some may struggle with substance abuse, some may struggle with any number of issues, to be able to have some discretion to make those determinations. I think with this population, it makes sense. And I know there's no way to say that without that sounding perhaps a little bit paternalistic and a little bit disrespectful. That only comes, though, from a place, I think, of legitimate concern on our part. But I think that's an additional factor that I think is important to remember here. The specific individuals that we are dealing with, or that we've seen so far come forward.
So I'm going to follow up on that and then go to Representative Erf and Representative Hatch. But so I think we're probably all in some degree of agreement on the idea that if the claimant is credible and able to handle their financial duties, that a lump sum is perfectly appropriate if that's what they want. I think where the discussion should spend a little bit of time is to say, to what extent does the administrator have the ability to inquire about the claimant's competency? Like, for example, let's say the individual has an active, ongoing drug problem. But there's not an open arrest. There's nothing clearly in the public record about that. But the person is incompetent because they're using drugs actively. How would this administrator even know that? And what sort of power are they going to have to inquire into the personal competency of the individual? And I'm less concerned about doling it out over time, because I think it also protects the state's interests to spread out the financial payments and to make sure that we don't create a new dependent on the state welfare system quickly because they blow through the money. I think there's a state interest in this, but where I'd get concerned about the confidentiality and the paternalism of it is when we start to talk about the administrator's authority to inquire into the personal lifestyle of the claimant, because I think there are privacy bounds in there. And what are your thoughts on that?
That wasn't something we had contemplated, that the administrator would have some affirmative duty to actively go investigate. I think the intention of the provision was to deal with the limited circumstance in which an individual presents, maybe without counsel, maybe decides to refuse counsel's recommendation to take a stream of payments, fires his lawyer and tells the administrator that he wants the money immediately. I don't anticipate that this is a provision that would necessarily get invoked frequently, but we thought it would be a good option, a good tool for the administrator to have in his tool belt in that instance. And I think that it's as you say, it's the ability for the state to spread those payments out, but I don't think that's the primary purpose of it.
Yeah, so I can believe it's a good tool. I just am trying to understand what the flow of information would be to allow the administrator to make an informed decision on whether or not they want to overrule the requester of a lump sum and opt instead for string of payments. I don't understand that.
So I think that in the part of the claim resolution proceeding, which is going to get built out as a part of the work that gets done after the bill is passed, the administrator, in consultation with the Attorney General's office and the plaintiff's counsel, is going to build a process that's something that could be addressed in that process with lots of input from plaintiff's counsel as well.
Thank you, Representative Irf.
Thank you, Mr. Chair. I'd like to go back to costs, if I may. I'm noting that when you eliminated the arbitrator, you eliminated the sharing of expenses when you went to arbitration. That says to me, you've removed any incentive to settle with the AG. Why would anybody waste their time there when there's going to be no costs associated with going to the administrator?
Timing, you could get a resolution with the Attorney General's office as quickly as 90 days under this proposal. It's going to probably take much longer, particularly in the early stages of this administration, to get through a resolution proceeding with an administrator.
A follow-up, if I may? You're referring to the claimant's concerns about getting paid quickly, but the attorney's probably driving the process, his attorney or her attorney. They don't have any time incentive. They have a money incentive. I mean, you took out a huge part of I think, the balance in the prior proposal.
Yeah, and I don't know if we're going to use an independent administrator that it feasibly makes sense to ask the claimant to pay a part of the administration costs. I also think that was an area where it didn't feel good to victims to have to pay for the privilege of being heard by the arbitrator. And so the balance that we're recommending kind of leans the other direction, but I certainly understand your concerns. That's the reason we had initially proposed the fee sharing. But on further consideration, I think the overall restructuring sort of makes more sense to have the administration fees be the way they are.
Are you okay?
Yes, thank you, Mr. Chair.
Representative Hatch, do you still have a question?
Well, thank you, Mr. Chair. I'm just thinking through this, and a lot of my questions have been answered by your questions, but in just thinking this through, and I just put my own circumstances in play. I have 6 children. They're all great, good kids, and 5 of them, if they received a bundle of cash, would be very responsible to it, and all good. 1, not so much. But nobody would know that except mom or dad or anybody close. So is there a way to allow the administrator to dole out settlement if he or she receives a preponderance or germane information from somebody that would maybe warrant consideration of that? Hopefully, some of these people have people close around them that understand them, and maybe they would have an avenue to present this information. I don't know if this makes sense or not. Hopefully, their attorneys, if they have one, would maybe aid in that event. Is there anything ever done like that, or is that sensible or not for this? I mean, I don't see an answer to this other than, you know what I mean?
It's a tough question, and ultimately it's something that you all will decide what you think is best, and of course, we'll work with whatever you decide. I think what you're kind of describing would be the possibility for other people to intervene, maybe to express their opinions, and I worry that might bog the process down in such a way that would be really problematic.
Well, thank you, if I may. I would just a venue to allow it to be considered. is all I'm thinking of, and not have a Pandora's box and end up being a nanny state or maternal thing, just some sort of venue.
Yep, and I think, let's not forget though also that separate and apart from this process, people like you're describing, there may be other avenues within the legal system for somebody to come and petition for a guardianship. I think in an extreme case where family members were concerned, there would be maybe other ways to address this outside of this process.
Representative Mooney?
Thank you, Mr. Chairman. Thank you for taking the question. At the time a claimant files a claim, is the claim based solely on the events that occurred while they were housed at the detention center, or can it and does it branch out into extenuating circumstances, as an example, what their lives have been like, been out of work, and so on and so forth, since their time at the detention center?
Yeah, it would just be based on events that occurred during their time at the detention center.
Thank you.
So based on your not just general knowledge of the cases, are we going to end up with any situations where there was contact post-incarceration between the prisoners and the guards? That would also, I would assume that would become extenuating circumstance if there was some kind of an ongoing relationship post-incarceration. Is that just, are we just talking about something that didn't happen, or is that possible?
I think it's possible that happened. I don't think we contemplate, though, that being considered as part of this process. I mean, I think that may come into play when you're looking at the likelihood that events occurred while they were incarcerated at a detention center, but I think we would not be considering contact or events that occurred once they were not in the relevant facility.
Thank you. I'm not familiar with these cases. I just am curious if somebody is willing to abuse their power as a guard, are they predisposed to being a stalker? So Representative Lynn.
Can I follow up just on Representative Mooney's question? I guess I'm not clear. I mean, wouldn't it be not at all unusual for someone who was abused, who claims to have been abused at the YDC, to say, as in support of their claim for damages, well, as you know, I maybe have an expert that would support this. Well, as a result of that, excuse my language, but my life turned to shit, and it turned to shit for a long period of time. So as example, I've frequently lost my job or been fired, and maybe would have to have evidence. So I could see a number of circumstances where things that happened later would be very relevant to damages.
Yeah, absolutely. I think I interpreted Representative Mooney's question, and maybe I interpreted it not exactly correctly, kind of as Representative Edwards raised. Like, would there be events that happened once they were not in the facility anymore that may be compensable?
That would be a basis for liability, right, as opposed to damage.
Like if because I have thought about this, and we have seen these circumstances where there may have been contact with an individual by a staff member after they were outside of the facility, right? So I don't think we'd be considering those events in a matrix or in a set of guidelines when it comes to determining compensation. But as for whether events that happened after someone was in the facility, whether those would be considered in deciding what the damages were or what the compensation should be, I think yes, that would certainly come into play, but that, or at least it could potentially come into play. I think that would depend largely on how these guidelines end up getting negotiated and how any claims matrix ends up getting negotiated.
Thank you.
So one of the questions I was going to ask, you basically just answered, but what I wanted to say overall is I sort of see this working the same way civil claims work in the judiciary right now. And that is, a measure of damages includes harm that continues after the act has happened. So, for example, if you broke your back and you can't work, that's part of the measure of damages, say, in a traditional civil claim. Similarly, it would seem to me that the judiciary has, sometimes they will do a lump sum award, and sometimes they pay the award over a period of time if it's obvious that there's going to be expenses over a long period of time. So, for example, when you have a child that is born with disabilities and that can be traced directly back to the birth process, and say you have a claim against that OBGYN, those claims can, that amount of money can be paid over a period of time or put in a trust that goes over a period of time. It would seem to me that the similar kinds of things could apply here, both for the measure of damages and for the payment of it, that we just use the systems, or we use as a precedent the systems that are already in place for civil damages. Am I wrong in thinking this way?
I wouldn't say you're wrong in thinking about that. I would answer your question though, just with I think what will be the answer, but also a comment. One of the things we're trying to do with this process is balance the need to be able to value these claims without too much. How can I say it? Too much sort of invasive questioning of how victims' lives have turned out, after they were incarcerated at YDC, or after they were in YDC. And so while that could come into the discussion, I think what we would not want to do is end up in a situation where, horrible things happen to a victim, but because they were able to pull their lives together, they necessarily were compensated less than someone who wasn't able to. And it's admirable when a victim can overcome these types of events, but I don't think we would necessarily want to put ourselves in a position where we're penalizing someone for not overcoming things like that happen to them. So while I do think we can, in valuing claims, we can think about what happens in the normal civil litigation process. This process is designed to be different than that, and so I don't think that the procedure for valuing claims will line up with traditional litigation.
But isn't that part of the measure of damages? If you've got somebody that abuse, that maybe they're fragile emotionally because they had other issues, before they got there, that would be the measure of damages. If somebody can hold a job, their measure of damages are going to be different than somebody who can't hold a job, will never be able to hold a job, can't be in a relationship. It seems to me that should go to the measure of damages.
Right, and that's why I'm saying I don't think it would be irrelevant. I'm just making the comment that it's probably not necessarily to the same extent as it would be if we were litigating these cases in court, because it's how this is going to end up. How these claims are going to get valued is going to be largely determined by the claims process that's set up and the guidelines that are agreed to and any value matrix that's agreed to. So it's hard for me to sit here today and know how much that's going to come into play. That's going to be a subsequent negotiation that has to take place. But my sense is that to the extent that comes into play, it will be less so than in the traditional litigation process, because you're right, Representative. If we were litigating these cases in court, that would be important. What are the damages that flow from this harm? I think we'll still want to consider that, but given the reality that we're going to try to design a very efficient process that it can move quickly, that is not too invasive and doesn't require too much examination of a victim's life, I think it's a reality that those factors won't be taken into account to the same extent they might otherwise be in traditional litigation. Did you have anything to add?
Attorney Ramsey, I don't want to cut you off. Okay, so as I listen to this, it seems to me like the guideline matrix that is going to be constructed is going to be really kind of critical to capture a lot of this philosophical trade-off sort of question that we're having. And I've never seen a guideline like this. This is not my domain. But I imagine that's going to be critically important to this whole process. What since that will occur after this legislation is passed and after the House has dealt with this, what process do you imagine for just getting sort of a legislative thumbs up on the compensation matrix, or is one needed?
So, just for a little bit of context, in some other claims resolution processes, the matrix looks a little bit like a chart of types of harm from very serious things down to not so serious things, with dollar amounts assigned or ranges of dollar amounts assigned for each type of harm. That will be able to be published, and claimants will know what their potential range of recovery is going into this process. So to your question, Representative Walls, it will be a little bit different than the litigation process, and claimants will be able to choose whether they want to go that traditional litigation route and have their damages fully assessed like you're describing, or whether they would like to participate in this alternative process, and they'll know the range of what they might be entitled to recover going in. In terms of the design of the process, the bill does not currently
Before we leave that, so also I imagine that part of that matrix are the extenuating circumstances that would help decide what part of the range the administrator would be on, and do you think you know enough to be able to describe what the extenuating circumstances might be? Will that be public knowledge as well?
Yeah, I think we had contemplated that the guidelines would be a document that would include all of the factors that might go into the consideration of where you would fall in the guidelines, things that have to do with whether the claim has been raised any time in the past, whether the amount of passage of time since the claim, whether the claim might have been subject to legal defenses in the event that it was litigated. All of those would be articulated at the front end so that claimants would understand the process. And then in terms of, did you have a follow-up?
No, I was just ready for you to go into the process. I didn't want you to forget where you were before I interrupted you.
Sure, no, not a problem. So in terms of how that matrix would be developed, we've obviously already been thinking about it, and I'm sure plaintiffs' counsel has as well. It was contemplated that we would meet and confer, and then the administrator would ultimately make the decision. This doesn't currently have a provision for legislative approval of that, but if you wanted to include it, one thing we had contemplated at one point was that we would adopt that by rule at the Attorney General's office. If we have an independent administrator, that might be more difficult to do. But if the legislature wanted to have oversight of the matrix, we could certainly build that in.
I wouldn't be asking for anything that's outside. This is not a normal thing we're doing, but I don't think it goes completely without precedent. So whatever the appropriate legislative oversight or participation would be, I would just ask that you guys think about it and let us know.
Yep. Yeah. Another option, in addition to adopting the process by rule, would be for approval by the fiscal committee. Say that's a fairly typical way to approve something in a more efficient manner, because we all know the rulemaking process can take a while. But we can think about that. I'm sure plaintiffs' counsel will also have something to say about that.
Yeah, so I would definitely buy off on the idea that once this is all set up, that it should be approved by the Joint Fiscal Committee. Representative Lynn?
May I just ask a question, really in follow-up to Representative Walsh's question? So am I understanding from what you're saying that the matrix would be mostly concerned with what happened to the person at the time of the abuse, as opposed to sort of damage kind of things? In other words, you would not have I'm just sort of talking off the top of my head, but it would not say that, for example, if the victim was never able to obtain steady employment, that adds X dollars to the claim. On the other hand, if the victim was able to receive steady employment, the victim, it's a lower amount. Because I think Representative Walsh's point is that, it seems to me that, if a victim, turned out to be the next Steve Jobs, we might say that it's terrible what happened to you, but your damages are X. And if the victim turned out to be like what may happen to what we might more typically think of happen to a victim, then the damages should be significantly higher, I would think.
Yeah, I think one of the differences between a process like this and litigation is that factor is not going to be nearly as heavily weighed. I won't say that it might not factor into the arbitrator's thinking at all, but the alternative process is actually designed such that a Steve Jobs would still be able to recover based on what had happened to him at the facility. And I think that's because of what Attorney General Formella said, that we don't want to penalize a person because they've overcome the obstacles that they were presented with. We want them to be entitled to recover based on what happened, not based on what they did later in life.
Right, no, sure. I mean, I understand. Steve, even the Steve Jobs should get something for having been abused, but that's different than saying that it would not. What happened to the person later on as a result of it would not have any relationship to how much money they're paid.
Yep. I think it. I think it certainly would have some relevance. My sense is it would factor in less than the traditional litigation process. And I also think it's difficult for us, to sit here today and speculate as to how much it's going to factor in, because I think that will be the subject of some pretty important negotiations and discussions. I think Representative Edwards made the point, and it's a point I think we've all known, but we haven't gotten to in our discussions so far. What these guidelines and any value matrix look like are going to be very, very important.
Okay, we've been at this for 90 minutes, 90, and I think we're at a clean point. We're about to start line 14. Is that right?
Yes.
So I'm proposing a 8-minute sort of recess so that people can freshen up. So we will reconvene approximately 11:35. Keith, would, so, in order to make good on my word, it's 11:36. That's about 8 minutes. So I'm going to end the recess on this, and the House is now in hearing again on HB 1677. In the fashion of the old Western serial movies, when we last left our intrepid hero, we were on line 14.
Line 14 is language on page 4 at line 16 to 21. And this is language that was considered and included for recommendation based on a comment that you had, Representative Edwards, at the last hearing about if we're going to have the claimants file under oath and be subject to referral over for misrepresentation, should we also do that with respect to the perpetrators that we may uncover during this process? I would love to say yes, but I think the better answer to that question is only if the claimant requests it.
Right.
And so that's the purpose of that change.
Thank you.
Yeah. Line 15, it's language found at page 4, lines 9 to 15. Again, in response to things raised at the last work session, we have included specific language to make clear that when claimants provide us with a release, that does not bar them from continuing to pursue claims against the perpetrators.
Representative Lynn?
May I just ask a question with regard to 14? I don't have any problem at all with the language that says a claimant shall not be required to cooperate in a criminal investigation as a condition of participating in the claim process. I have no problem with that. The earlier sentence, though, I guess, which says that perpetrators of sexual abuse identified by claimants may be referred to an appropriate law enforcement agency by the administrator, but only with the consent. I mean, that strikes me as a, I guess I was always under the understanding that the state decided who gets prosecuted and who doesn't, not the victim. And so I'm kind of concerned about subjecting the state's discretion to the victim's. I mean, certainly, I'm sure the state would take that into account, but to say that the victim controls, seems to me to be
Yep.
a little untoward.
So I would just point out that this is language that refers to the administrator, but not to the state. Nothing here would bar the state from making a determination to prosecute someone. And as we're all aware, there is an investigation ongoing. So this would just be whether or not the administrator would independently make a referral to the state for that prosecution if the claimant did not wish to do so. In other words, we don't want to force the victims to participate with the criminal investigation if they simply don't want to. Just as a part of this process.
And the Attorney General's office involvement in this process will be such that I think we would see any information that the administrator would see that would lead to some determination that there may need to be a criminal review or criminal investigation. I don't think the administrator is going to get information that we're not.
That you're not aware of. Okay.
Yeah.
All right.
So,
I see your point.
So the AG designee may take it and pass it over to the Criminal Justice Bureau, and the Criminal Justice Bureau can decide at that point how to approach it. But the administrator would not have an obligation on them to make a referral, unless the victim consented and wanted them to have
Okay.
it.
All right.
So the key sounds like there would need to be some kind of a referral. Do any of you lawyers sense that referral process needs a mention in this legislation, or is it sounds like Representative Lynn, it's assumed?
as long as the Attorney General points out, as long as this is not construed to limit the AG's authority to initiate a criminal prosecution, from what you've said, I take it you don't interpret it that way, then I'm fine with it.
All right, Representative Long, I don't want to put you on the spot, but you had written a marginal question here in your notes, and I just want to make sure if you had a question that we got it addressed. We're on page 4, topic 15, and your notes are on the right. It says something like, pursue civil action against petitioner.
Thank you, Mr. Chairman. Yeah, the perpetrator, it appears that that would be the case. I got my answer. Thank you.
All right. I think we're ready to go.
I think we were ready to move on to number 16, which is language found at page 7, line 31. This is an improvement we recommend based on concerns that we don't want to cloak this process completely in secrecy. And so we would recommend that the administrator also include basic information about the nature of the claims that are being made in the public disclosure of what's going on at the claim process without identifying any claimant, but the nature of the claims being made.
So I think we had a conversation on this last time, and the Attorney General has provided an example of the settlement fund award and release, which is extremely helpful to know what you're going to make exposable. What I had been asking was for a template of the format of the report that would come forward, but maybe this is better way to answer my question, because this is I assume this is all the source documentation, and any sort of a summary report would just 100% be summarizing these.
Yes, I think that's correct. In addition to the financial information about the expenses of the fund.
Okay, so I'll withdraw my request for a template of the report because you've given me the source document. Thank you.
On item 17, page 8, line 13, we've moved up the effective date to the date of passage. Number 18.
Can we go deeper there?
Of course.
I think associated with the effective date conversation, we also talked about the wisdom of putting a suspense date on this, or not a suspense date. What am I looking for? The sunset date. Did you guys think about or talk about a potential sunset date on this legislation?
There is a provision of the legislation that we would hope survived sunset, and I think other than that provision, we could include it. And that's the provision that talks about once publication is made, we would treat that as notice to the community for purposes of limitations, so that if someone were to come along and file a claim 10 years from now, those claims would be subject to the legal effect of having had notice of your right to bring a claim earlier.
So I'm interpreting that to say that there is a section of the legislation that should survive, but the rest of it can be closed down. And so for the parts that can be closed down, as a legislator, I think there's value in having sort of a self-cleaning attribute to the legislation to remove itself when it's no longer relevant.
I agree with you, and I think we can include that, although we haven't yet.
All right, thank you. Was there a question? There's a question.
Should the legislation be removed until such time as the 10 years of, paying out the claims? Shouldn't that be the sunset of this? I'm just saying that, we don't want to sunset the legislation when there's still, in fact, maybe claims to be paid out through whatever the date was, 2032. So that's what I took as the sunset date for this legislation.
I don't disagree. I just would like whatever the proper way of saying that for us to consider it and put a sunset date on the portions of this law that could be sunset at that point, right? Or at whatever point.
That seems like an appropriate date to me.
Okay. Comment, Representative Umberger?
No, I'm fine.
Okay.
Item 18 is at page 2, lines 32 to 33. We want our victim witness advocates to participate in development of the claim process. And recommend that as an additional source of input as that development process is occurring. And similarly, item 19, which is in a couple of places, a couple of lines on page 5 and then a couple of lines on page 6. Again, we recommend that you include the right of the victims to have an advocate there to support them as they're going through the process. Item 20.
If I could just ask a question. In the normal process, if a person is represented by counsel, does the victim witness still get involved?
Yes, I think so.
Okay,
Yeah.
I don't have any, I mean, this is a good thing. I just wanted to make sure that this is not one of those precedent-setting things, but rather the normal process for this sort of thing.
I think they might still have the right to do it, even though the language wasn't in the bill. But I think it's good to make clear to victims as a part of making sure they understand and are comfortable with the process.
Okay, thank you.
Item 20 is at lines 13 and 15 on page 6. This is an inclusion that came out of discussions that we had with the administrator of the process for the diocese in New York. One of the things that she stressed was that it was important to victims to be able to sit down face-to-face with the administrator and feel that they had been heard, and to do that in a private setting without the Attorney General's office present. And that seemed like a very good idea to us, and we recommend that you include that as well. Item 21, page 5, lines 8 through 30, is to clarify that the investigator will just serve as an independent fact finder and won't be making recommendations for resolution. That's consistent with kind of the shift of this bill to create a more independent process. And then,
Yes, Representative
May I
Lynn.
ask a que- Can you, other than this, other than the New York example, is this something that is kind of standard? I mean, it does strike me to be, particularly since the victim will have an opportunity, if the victim wishes, to testify before the administrator, to allow a person who is an adult to have with their counsel sort of an ex parte meeting with the decision maker does seem to me to be, a bit unusual. And so I'm wondering if this is there any other examples besides the New York one?
that administrator has actually administered quite a number of similar proceedings, and it's something that they've incorporated in their process, is my understanding, across the board. I don't know beyond that particular administrator of examples where that's been incorporated. It is not consistent with sort of the judicial way of usually resolving claims, but since a part of this process is about sort of healing, and at the point that this occurs, this individual will not be going to court because there will have been a waiver of litigation rights. So with all of those considerations and this trying to be an alternate process for these folks, we thought it was in the balance better to allow that to happen.
May I ask you
Go
a
ahead.
follow-up? You know, just one I mean, I guess one of the other things, and this is maybe a bit, it goes a bit beyond this particular thing, but that sort of assumes that there's no question about the claim. I mean, it's the, I mean, don't get me wrong, I'm sure that many of these claims are valid claims that should be compensated, but I guess I'm not sure that we can say that all of them fall into that category. And so if there's a contested case where there's really a claim, really a question, did the abuse occur? To allow the victim to have an ex parte stab at the judge, so to speak, it seems to me to be. I'm very troubled by that idea.
So I wouldn't think it would be the only information that the administrator would consider. So if there was some question if whether or not the abuse actually occurred, that would happen during the Attorney General's office would have an opportunity to participate and try to elucidate those issues during a different phase of the claims resolution process. That's to be developed once the administrator is appointed and with all of the parties in consultation, so you don't see that in this legislation yet. But I understand your concern, and I think that it's not something that absolutely has to be included, but it's a recommendation that we think would help victims to feel like they want to use this process, and that the process helps them to have some closure sometimes.
I'd like to just add a couple comments to that. I think that I definitely see your concern, Representative Lynn, that we wouldn't want to set up a situation in which a claimant, a victim, can have a private conversation with the administrator, perhaps give the administrator information that the AG designee doesn't know they're alleging, and make a case without an opportunity for the AG designee to respond, right, and perhaps present an alternative view of what happened. I don't think that's not the intent of this. I mean, the intent is to give the claimant their opportunity to just talk face to face with the administrator, say what happened to them. If this process is working the way it's intended, they will already have submitted that information when they submit the claim. And so I think we could probably build in safeguards to ensure that while they get a private face-to-face meeting with the administrator, to the extent information is conveyed in that meeting that has not been conveyed in any other way, that information needs to be shared with the AG designee. But perhaps the administrator could do that. I think the point of this is it's really about, I think, what can be a powerful outlet for victims, giving them the opportunity to have just that private face-to-face meeting with the decision maker. But it's not intended, I think, as you are concerned with, and now that you mention, I think it's a legitimate concern that we need to think about. It's not intended to give a victim a free shot at the judge, so to speak, and convey information that the Attorney General designee is not going to have an opportunity to respond to.
Could I have a
Follow-up?
I'm just wondering, I mean, couldn't you, since these proceedings are going to be private, not, sort of not open to the public, couldn't you accomplish the same thing by having something that would say, the victim shall have an opportunity to personally address the administrator at some point during the proceedings, but, that would be in the presence of the Attorney General's representative, something like that.
I think it's absolutely something we can think about, and because I see the concerns, because we're trying to create what's in some ways a mediation, an arbitration, and an administration of claims, and it's kind of all in one, right? And so I think in balancing all those, we need to make sure we balance it correctly, and in trying too much to give an outlet, we don't give what essentially would be a competitive advantage in what is still at least softly, can be an adversarial proceeding if the AG designee has a different view of the claim than the claimant.
Thank you.
Yep.
So Representative Emmerich and then Representative Walls.
Thank you, Mr. Chair. This seems to me to be the grease skid to move every case into the administrator. And the claimant, are they going to know that the price just went up? You know, because if I'm representing a bunch of people, I'm going to say, gee, you really ought to talk to the administrator. I mean, and it brings no value to the case, but if the attorney says you should really talk to the administrator, boom, 33 1/3% from 25 for one conversation. And as a claimant, you didn't tell me that. Well, you didn't read the law, okay? I think this is a really bad idea based on, I'm looking at it from the dollars and cents side now. I understand from a human side why this is a good idea, but I think you could almost put somebody over in the corner that says, the public, here's your chance to talk, go for it. And it doesn't have to be the administrator. You know what I'm saying? It could be a cardboard character, for crying out loud. I think this is a bad idea for process purposes and financial reasons.
I'm hearing your comments and I understand them. I think we need to give that some more thought as well. The goal would be to help the victim with healing, but we need to think about the financial consequences of having people choose the process in the way you're describing.
Thank you.
Representative Walls.
Thank you. You know, one of the things, all my terms, my 4 terms on children and family law and National Conference of State Legislators sent me out to national conferences teaching me about trauma-informed care and trauma-informed processes. And what I'm hearing from some of my friends on the committee is a concern that's a very legal concern, but doesn't recognize that this is a trauma-informed process. And that under a trauma-informed process, you need to have some unique things like the victim have the opportunity to speak to the administrator. And I'm wondering if we can't recognize this as a trauma-informed process, continue to have that ex parte meeting, not have it trigger, necessarily go up to a 33%. I don't think it has to trigger that. I think it's not the same as a full back and forth on behalf of the lawyers of an advocacy, just one meeting. But I think we've got to recognize that we have very traumatized victims, and we need to continue to have a trauma-informed process that has processes that are outside the traditional civil approach to these kinds of things. And that's the whole point of this, is that this is a trauma-informed process that allows things that are non-traditional to occur.
I'm going to take a shot at that just first. So Representative Walls, I hear you. I share your concern. I think the AG came in here today with a proposal that was very centered around how to respect the trauma-informed intervention. And what we're hearing is that there's another possibility in this world of ours, which is that somebody could come up with a false accusation, and in that situation, if they get strictly and completely a moment of quiet with the administrator where they can say pretty much they want whatever they want without challenge, that can create an unreasonable risk to the state. And so what I hear, what we're asking the AG to go away with is to just rethink through this. How do we maintain the integrity of the trauma scenario that we're dealing with while still finding a way to protect the state's interests too? But I'm okay with the first priority being worrying about the trauma environment that the victim is in. I just don't want to accidentally give a ne'er-do-well a shield.
I would agree, Representative. I just didn't want the opportunity for a victim to meet privately with the administrator to disappear, because I think that is part of a trauma-informed process. I think these victims are going to be totally intimidated by a traditional process, and I think that just as the mediators and other things have learned that that's an important part of a process when you have these kinds of victims, that's why I wanted to address it.
Thank you. So now that you've just heard the sidebar, do you want to jump into the Shark Tank and tell us what you think?
I think there's a way that we can separate the face-to-face from the adjudicative process and make both available so that the victim can be heard and have the healing without that triggering the economic reward becoming different.
Yeah, I guess, I mean, one of the things, you know, I guess where I differ with Representative Walsh is I think that we need to recognize that this, you know, particularly if you're talking about something that happened a long time ago, where the alleged abuser is dead or no longer around or whatever, there is a ripe opportunity for someone who would want to take advantage of the system to take advantage of the system, and there needs to be ways to ensure that that doesn't happen. And for example, you know, one of the things that I absolutely object to is on page 4, in subsection F, where it says claims shall be submitted under oath and shall be presumed to be truthful. I would absolutely take that out. I mean, you know, why are these claims to be presumed to be truthful any more than any other claims in any other setting? It just seems to me, you know, the claimant, I would assume, has at least some burden to come in and say and convince the Attorney General in the first instance or the administrator eventually that, in fact, what they say actually happened. So that.
I think the wisdom of that and whether we should do that is for you all to decide based on the discussion you're having right now. I can tell you the reason that we included that language was to provide the incentive to victims to come forward and to not be concerned that they were going to suddenly be cross-examined and not believed to be truthful. And because what we're hearing is that coming forward with an allegation like this is an extremely difficult process and that the victims need to be treated in the first instance like they are telling the truth. That doesn't mean that somewhere in the process we wouldn't discover otherwise, but the design of this is, in that particular instance, leaning towards the more trauma-informed approach, but that is a decision for you all to make.
So I would be more comfortable with saying presumption of being truthful with shall be treated with respect and dignity, because it seems to me like that's what you're trying to achieve, and we don't want to create a legal argument where there doesn't need to be one. Is that?
I think that's an excellent suggestion.
Thank you. Yeah.
I would suggest that the presumption does need to be there. You're talking about such a power differential here. You're talking about people who were incarcerated, they were abused by guards, there were no witnesses. Believe me, any one of those victims can probably tell you in great detail today, even if it's 20 or 30 years later, exactly what happened to them, because it never leaves your mind. And I think that when you just make them try to prove everything they say, they can't. They can't, because there's no witnesses, there's nothing there. There has to be some sort of recognition that they're not making this out of whole cloth. And I think just like any witness on the stand, when you question them after a while, you get a sense as to whether they're lying or they're telling the truth. And I think that it's going to become apparent with these witnesses when they come forward and with these great detail of exactly what happened to them, that you're going to know whether they're making it up or whether they're telling what they remember. And, you know, for some of these victims, that is the only way that if you understand that you've got to presume it, because these guards were very clever. They did everything they could to make sure there's no fingerprints.
Respectfully, I couldn't disagree more. I just think that this is, so we, take it, we should just, this goes, to take it on a certain, we should presume that whoever said Justice Kavanaugh, abused them, that we should just presume that what they said is true. That's the way we should start it. I just cannot accept that.
Representative Umberger?
Yes. I think that I understand the argument on both sides, but the point is that we will have investigations of these allegations. It's not like, you know, whatever they say is automatically going to go forward, right? I mean, we're investigating it, and so what I think this says is that if you come in, that we will presume that you're telling the truth, and then through the investigation process, we will determine whether or not you are in fact telling the truth. And so this I think, if I understand it correctly, is simply to get the people through the door. And then the investigation will determine whether or not it's true or false. Just because it's presumed doesn't mean that it's going to move forward. It just means that we will accept your allegations and go forward. And that's not a lawyer talk, but that's
So neither of us are lawyers, right?
right.
So I don't know if that, the second part of what you said is built into this, that whatever is said, it will be also subject to the investigation. And if we get into a hard position where the presumption of truthfulness is in there, you know, I would just ask for an independent read to say that initially presumed, perhaps, subject to other factors or qualifications. But I don't want some administrator to read this and say, hey, I have some serious doubt here based on my life experience and my ability to work with people, where I don't really believe everything I'm hearing, but it says in the law I have to presume truthfulness and put more weight on that statement than I think I should. So you all have heard the conversation, and so, you know, I'm not going to be resolving it, but I just, if you would come back and address this specifically, because I hear Representative Walls, I hear Representative Lynn, and I just want to make sure that you guys think through it.
And we will do that. Thank you. I think we will focus on trying to come up with something that allows for the truth to be got at during the process, but also tries to incentivize people to come in the front door, as you say, Representative Umberger. We are almost done. So number 22 is actually a duplicate of an earlier one. I don't think we need to talk about it again. And number 23 is the very small change in language at page 7, line 12. And it simply takes a may to a shall, so that the administrator will have a requirement to come back and ask for the fund to be expanded if we find ourselves in that circumstance.
Okay, so I think this has been great. So for the committee members, it's easy for us to know what we just talked about, but what I'm going to ask you to do is to think about this in terms of, is there something that you still believe needs to be discussed that weren't in the AG's notes? Did we overlook something? You know, not because we want to, but just because of the process. Representative Walls, and then we'll go Wallner and Emmerich.
That's fine. I do have one thing. It was actually what's in 23, but I also want to ask, before I get to that, are we going to hear from Attorney, I'm never going to say this right, Vincent?
I plan to. I intend to.
Thank you. Sorry, I will learn how to say his name. So the lawyer in me, this one caught my eye previously, and we have not discussed it in this committee. And it says here that there's a requirement that the administrator ask for additional funds. But I have been in this legislature long enough to know that just because somebody asks for the funds doesn't mean they're going to get it. And in a normal civil proceeding, if you win a judgment against the state, there's a number of ways to recover it. You're not limited to a particular fund. And I take you back to a little bit of history, to when Mel Thompson was governor. And there was a fight with somebody that went all the way to the Supreme Court that about whether or not you could tape over on your license plate something that said "Live Free or Die," and the state lost it, and the plaintiffs won a judgment against the state, and Governor Thompson refused to pay the judgment. So what ended up happening was the feds went into the liquor store and said, "Open the cash register. We're taking the money," and they immediately called the governor, and the governor said, called the treasurer, whoever he called, and said, "Cut the check." And the point being is that they had an alternative way of getting the money. They weren't limited to a specific fund set up by the legislature. And I'm concerned that future legislators might choose not to further fund a fund. And I'm wondering if there's a way that we should be putting in here to protect the victims here, that they're not dependent on the whim of the legislature to fund the fund, but that they have a way to recover from the state, even if the legislature doesn't fund the fund, if they have a valid judgment against the state.
Do you think you might have recommended language around that, or are we going to do what we've been doing and ask the AG to think about it and come back to us?
I think it would be very easy to do it. There is a provision, I don't have it in front of me at the moment, but I did notice that there's specific language in here talking about the money coming from the fund. I think that language can be easily amended so that you're not limited to the fund. So I think the AG, I think the plaintiff's lawyer, I think anybody could, I mean, again, I don't have it right in front of me at the moment, but I think it'd be easy language to amend it. You're not limited to the fund.
I'm open to considering it. It's hard for me to imagine if we have valid claims against the state, the legislature not doing its job and appropriating the funds. But this is only my third term, so your cynicism may be well deserved. So, do you all have any comment on this discussion?
Yeah, I think my comment on that is one of, on a number of these things, we would say ultimately it's a decision to be made by you. This is, I think, especially that type of a decision, but I still will comment on it. I generally would recommend against an open-ended appropriation. I think institutionally, I think in the day and age we're living in, I don't doubt that our legislature would appropriate funds to pay claims that have gone through a process that's set up that were validly awarded. So I guess my general comment is legally I would never recommend to you that you have an open-ended appropriation. And second, I think institutionally it is better not to presume that the legislature would not appropriate additional funds for commitments that it made. I think it's better to presume that it would appropriate additional funds for commitments that it makes. So those are my comments. But we're happy to think about this if you would like us to, and think about language.
And thank you for throwing the word presumption in there a couple of times, just to remind us what the word means. So, did you want to say anything to that, or shall we go to Representative Wallner?
I'll just say real quick, we all know one legislature can't bind a future legislature. That's one of those lessons you learn if you've been around here more than one term. And that's where this concern comes from, is that what we're doing here, we are not binding future legislators and legislatures or legislators. So that's why I'm thinking that, we should not be limiting it to the fund that we are funding now, because we don't know how this, if there's some sort of, the economy crashes or something, that the legislature is going to go, we don't feel like using that money right now. We're short money all over the place. And that's why I don't want to presume that the legislature will, given this unknown future, decide that they're going to fund this. And I think that these victims should have the same rights as any buddy who has a claim against the state.
Thank you. Representative Wallner?
Thank you. I just have a couple of things that I would like to hear a little bit more about. One of them being the section where you talk about the administrator and the choosing of the administrator, and that the claimants council would, I'm sorry, that the claimants council would have input, and instead of being more involved at that point. Can you just speak to that?
You mean that the claimant's counsel would not be more involved, or that the Attorney General would not be more
That the,
involved?
the claimant's counsel would not be asked to agree to the administrator.
Yeah, I think it is drafted currently in such a way that both sides would have to agree to the appointment of an administrator, or otherwise the claimant's counsel would simply recommend to their clients not to participate in the process.
Okay, thank you. I want to hear more about that. The other part that I continue to think about is the physical abuse and claims of people who were physically abused and not just sexually abused. Have you given any consideration to that?
We are continuing to think about that. We haven't made any modifications in these recommendations to you. That you're not alone in that concern. We have not yet included recommendations that the scope of this be expanded to include other types of claims, because we haven't yet arrived at a way to do that within the structure that exists in this bill. So a claim of sexual abuse, there's just no circumstance in which that is okay. And so a presumption of truthfulness and a way of vetting claims for a sexual abuse claim is what this bill is currently designed, or our recommendations to you are currently designed with that approach in mind. But when you move into an arena where you have claims of physical abuse or emotional abuse, those things can be characterized that way, but they can also be characterized as activities that happen in a detention facility. It is a physical environment, it is an emotionally difficult environment. And so the vetting for those types of claims would likely look different than this process. And so we are continuing to think about ways we might be able to include those, but we haven't yet arrived at a way that we're ready to recommend to you.
Thank you.
So I've thought about this issue about how physical abuse fits into this since the last meeting, and knowing that this was important to Representative Rogers. And the way I've come to view it, and please tell me if this is a decent way of looking at it, is that we're setting up a very specific program for a very specific purpose. We know that there's been sexual abuse. We know there's a lot of claims. We want a special process to take care of that. And within the claims process, if there's been physical abuse on top of or in addition to the sexual abuse, then that's an extenuating circumstance, and that can affect what the payout may be. But if it's purely a physical abuse claim, we already have structures, as I understand it, for those claims to be filed in the ordinary course of business. And so it isn't that we're saying that we don't care about physical abuse only. We're just saying that is outside of the scope of this special program. Is that reasonable?
Yes, it is. I think the way this is currently drafted, it includes exactly that sort of thought process.
Representative Emmerich?
There was in one version of this, we have many versions. It said to the effect that the cases or the plaintiffs will be taken in the order in which it's received. My only comment on that was to say if it's complete, because there was quite a bit of verbiage about having a completed file. So you got to modify, we'll take them in the order they're received, completed and received. You know what I'm trying to say? Otherwise, somebody gives you they're third in the door, but they give you 10% of the information. They start screaming, you can't go to number 4. I'm number 3. So
I do understand what you're saying, and if that's still unclear, we'll work on that.
yeah, I can't find it in the new version. So
Okay.
Representative Umberger?
Yes, this is easy. On page 7, line 29, it says that the administrator shall annually submit a report. I would like to say that I would anticipate that the fiscal committee would like this as well, but would like it more than annually. And so, you know, I would suggest that we at least go to quarterly. And I say that just because of what Representative Wallace was talking about, that we need to know when we are coming close to that, you know, $100 million figure. And it's not, you know, it'll probably not get other than cursory looked at until, you know, a year or more. But we need to have the background for that. So if we could just change that a little bit.
We
Appreciate
can
it.
include that. Do you have a concern if we start that a little bit of the way into the process? In the early phase, it's going to be all about design.
Right, no,
Okay.
that's, you know,
Okay.
I don't care when, you know, but
Okay.
I just feel that we need to be able to track what's going on with the fiscal committee. Thank you.
So I agree with that quarterly issue, and maybe in year 5 we can drop it to some other rate, but certainly in the initial phase. Earlier we had talked about a conversation having the matrix reviewed by the Joint Legislative Fiscal Committee. Of course, I meant the Executive Council too. I didn't mean that standard process of how we do that is what I intended. I didn't mean to ignore the Executive Council and Governor.
I'm not sure that should go to the executive council. The matrix, that's not part of their role, is it?
Yeah, I've seen other legislation where something has to come back before the fiscal committee to be approved. I think this is the type of instance where it wouldn't necessarily go to the governor and council. I think that, you know, and I say this, and I think the governor would probably agree with me, so I don't want to get out in front of him, but even though he's a client, you know, that would set up a situation which the governor alone, when something has to go to governor and council, the governor alone can stop it, right? You know, so it's one person, and the executive council will not have been nearly as familiar with all of these discussions. I mean, this and what went into crafting the legislation. So it's typically a fiscal committee and governor and council process for spending money, and this is spending money, but it's not as if each individual claim is coming through to be approved. It's just the general guidelines. And so it's ultimately up to you, but I do think this is a situation which if you didn't include the governor and council, I don't think that would seem like an unusual omission. It would actually seem unusual, I think, to submit something like this to the governor and council.
I appreciate the education and the grace at which you just both told me that I'm wrong. It's okay. I withdraw my comment. Representative Walls.
Thank you. I had another thing that occurred to me that we did not discuss yet today, and that is the $1.5 million cap still in this legislation? So given the more recent settlements and the more recent cases that involve sexual abuse, like the Larry Nassar cases, and the size of the settlements and judgments in some of these more recent cases, I think we should revisit that. And we should be looking at a broader selection of, you know, what are the recent settlements and those kinds of things. And I think that should be incorporated into that. And we should re-examine whether 1.5 million really is the right cap.
Before you answer, I feel obligated to let the people who have been waiting patiently for House Bill 103, I think we're going to have to postpone the hearing on that. I'm sorry. We've got several people that in the Brain Trust here that require a 12:45 hard break, and we still have a couple of people to hear on this bill. So if you're one of the patient ones, you have my apologies.
Thank you for that, Representative Waltz. I think to that I would just say, to keep it short, I think we have been and we remain open to reviewing additional data that might, in consideration of whether to increase that cap. We've done our own research, and I still feel pretty strongly that 1.5 million is an appropriate cap, but we have invited plaintiffs' counsel to provide us with additional verdict research or settlement research on that front. We have yet to receive that to this date, but we're happy to look at that if that's provided. But I think based on the research we've done, and we're certainly open to reviewing other research, we remain confident that 1.5 million is the appropriate cap.
Representative Erf, did you have comments? We had a hallway conversation about the 1.5 million cap.
Well, I think it's where it should be for the time being, yes. If that's what you were referring to, that conversation.
All right, I just didn't want your comments left out. All right, so I don't know that we're going to resolve that today. If you wouldn't mind sticking around, we have the plaintiff's attorney. The last name apparently is so hard to pronounce that I'm just going to invite you to come up because you know who you are, and I'm gonna give you like at least 5 minutes to just riff and do whatever you want, and then but I would like you, before you end, I would like you to stick your finger in specific parts of where we are with 1677 and tell us if you are if you have a disagreement that the public should know about. And then Representative Shapiro, hands up. What's up? So what I have to do for procedure is I have to open the hearing on HB 103, and then immediately I'll be putting us into recess on it, and I'll be scheduling it for 10 a.m. on the 24th of February, probably in this room. Yep, sorry. I hope you were fascinated by this great conversation. All right. Would you introduce yourself for the record? And I think you're going to have to spell your last name.
I will. And again, thank you, Representative Edwards. My name is David Vicinanzo, Vicinanzo, and I am used to spelling it 10, 15 times a day. So, ever since I started working, it's actually phonetic, but it's a difficult when you look at it. I'm not going to be able to do quite what you've invited me to do, Representative Edwards, today. I can't go through, and we don't have the time. We don't, but I can tell you that we have been doing that with John Formella and with Jennifer Ramsey, and we, especially in the last week, have had some very productive conversations, in my view, at our court for the next draft, and then we are going to turn it around as quickly as we can with a more comprehensive red line. We did do a red line, but it was so comprehensive that nobody could follow it. We're careful lawyers, and we got lots of ideas, probably too many. So I'm not able really today, and I understand that there will be another opportunity in the future, but I think today's premature, and it really will take longer than we have. What I want to do, though, is focus on the three core principles that we believe, and we think the experts believe, are essential to a productive and successful and effective and fair settlement process. And it really boils down to, and we've talked to many experts, and I know Jennifer Ramsey has as well, and John, and we're learning. And I've learned a lot because I've done hundreds of these, mostly in the form of mediations involving historical child sexual abuse cases. So I have a good feel for how they work, and I have a couple of words at the end I'd really like to address some things that Justice Lynn said. I'm sorry, Justice Lynn, it's a force of habit. I'm not sure I'm ever going to lose that habit. But the three core principles that the experts agree are essential to a fair and a fair process that can be fairly described as victim-friendly, and trauma informed. First of all, including all the child victims in the process. I know that there are ways you can divvy them up, and you can segregate half or more of them and say, no, you're not invited. You can do that. I know there are legal distinctions and there are technical distinctions. But what victims hear is that my trauma is not as important as other people's trauma. My trauma that has so severely affected my life is given a lesser priority. And no matter all the words we might say to try to mitigate that and explain why, well, there are legal differences and so forth, they're not going to hear that. And frankly, I don't want to be the one, I will not be the one to deliver that message to them. I'm not going to say that I am in favor of discriminating against some victims in favor of other victims. I just don't think that it's a good idea, and I think it's a bad thing for the state to do. I don't think the state wants that perception. Yes, sir.
I just want to track along with what you're saying.
Yeah.
Because what I think I'm hearing in processing is that the AG, from my perspective, and Attorney Ramsey have done a good job. They're not done yet, but they've done a good job of making sure that the trauma-informed respect is included in this. And I'm hearing, though, that you may not accept that that's true. And we have language for you to look at for that. And then as you're talking about respecting all victims, I again, my perception is that we're doing that. And if you don't, I just need you to be really clear.
Yes.
Like I need to know your position on, for example, the physical abuse being a carve out and being left to the standard.
I'm very happy to do that.
All right.
First, I want to say,
and I hate to interrupt sort of your overview because I know that's.
I appreciate it. It's a good way to kind of cut to the chase and actually clarify the message. But
Thank you.
I wanted to say I absolutely do agree that John and Jen Ramsey are trying very hard to make it a trauma-informed process. I believe that. But for all of us, it's an education. This is not an area that we're all born knowing. For me, it was very much an education 20 years ago when I was thrown into the middle of the church crisis. And I've, in one way or another, been involved ever since. Generally, well, you might say the defense side, but I've never viewed it as plaintiff defense. I've viewed it more as a collaborative process to achieve justice and fairness for everybody involved, and hopefully some measure of reconciliation between people who are tremendously harmed and the institutions that did the harm. But it's a process. We have to learn. I've been speaking to one of the preeminent experts on child, especially adolescent trauma. His name is David Finkelhor, and he is right here at UNH. Been doing this for 50 years, since he got his 45 years since he got his PhD at Harvard, and is very much a nationally recognized expert on the subject. What he's told me is that his research indicates that as bad as sexual trauma is for an adolescent, violent trauma is worse. And even worse than sexual and violent trauma is emotional trauma. And he says it seems counterintuitive, but it's true. And of course, in our case here, the emotional trauma, there's a lot of emotional trauma. Usually it's attached to physical or sexual. Occasionally it happens without the physical, without the sexual, and that would be the instance in which kids were confined a month at a time, sometimes 2, 3, 4 months at a time in a cell without any human contact. That's the worst kind of trauma. But that's being excluded from this bill. I know that it's maybe a little tougher to wrestle with because it's not such a bright line the way sexual abuse is. Everybody knows sexual abuse is off limits. And yes, there may be times when certain amounts of confinement might be appropriate, and it might depend whether it's the 70s or the 80s or 90s, in which our understanding of what was appropriate for adolescents was at the time, or what the policies were. But we could wrestle through that in this process. There's no reason that the right administrator with the right guidance can't handle all the victims. And I think the state has a tremendous incentive to do it. First, we don't want to discriminate. Child victims are child victims. They all suffered, and they're still suffering today. And the other incentive is they're filing lawsuits too. And do we want to get a process that's going to work here, that's going to be attractive to the victims and successful, so that in a year from now, we can say that we've done the right thing and we're starting to put this in the rearview mirror? Or do we want to allow the litigation to clog our courts for the next 2, 3, 4 years? And a constant stream of news reports about, what the allegations are and what the latest thing in the litigation is. I don't think the state wants that. I really think the state has a tremendous opportunity here to actually deal with this in a victim-centered and fair way that accounts for all the human suffering that unfortunately was inflicted, or at least allowed to be inflicted.
May I
at the hands of
interact
the
with
state.
you on this?
Yes.
Okay. Are you telling us that if there were a juvenile that had been subjected to unreasonable solitary confinement over a prolonged period of time,
Yes.
that individual today and in the past has had no or inadequate access to having their case receive justice? Are they excluded from the today's process and current process?
Well, they're excluded from this bill. Is that what you meant? Yes.
No, I mean,
Yeah.
we have a system where people can apply and go through a settlement process with the AG. And I just want to make sure that in the earlier discussion I had, and I think it was Attorney Ramsey who confirmed my understanding, is that the physical abuse is an extenuating circumstance within this bill, but that cases that are strictly physical abuse would remain the province of the standard procedures. And so as I'm listening to your testimony, and I'm sorry to interrupt, but we're starting to run out of time, is I just want to make sure that we aren't leaving here thinking that those kids who have been physically abused or unreasonably incarcerated in solitary confinement, I don't want to I just don't want it to be the case that we don't have a process set up now already for them to go through.
Well, the only process I'm aware of is the judicial system. That's all that exists, and that a lot of these cases do involve those are emotional distress, emotional torture, confinement, physical abuse,
okay.
broken ribs,
So
lost teeth.
your position is that that's inadequate.
Well,
It's
no,
there, but it's inadequate, and we need to roll it into this special bill.
The word inadequate, yeah. What I would say is, phrasing it more positively, is this is a great opportunity to take care of all of those in an expedited fashion. There is a way to bake into the matrix and into the process of the administrator that you can account for the differences between sexual assault and physical assault and illegal confinement and so forth. All the arguments will be made by the Attorney General's office. There may be mitigating or extenuating circumstances in some of those cases, but that can all be baked into the process. And it's so important that we get an administrator who is wise and very familiar with New Hampshire law, has a lot of experience with this, and is trusted by everybody. And that's the kind of person that will say, well, I hear what you're saying, that you were confined for 3 months, and you couldn't even talk to your parents, and you didn't talk to anybody, and it was a terrible thing.
I didn't mean to lead your testimony too much.
Okay.
But we really have a hard stop at
Yes,
12:45, and your conversation with us
Yeah.
has clarified the issue that we need to think about.
We think
So-
it should encompass everybody. We don't
Okay.
want to discriminate against any of the victims.
Yes, sir. I respect that opinion.
And we're continuing that conversation with the AG.
You mentioned there were 3 things,
Yes.
and I think you just did one.
I did one, and the second one is somewhat related, and that is that we are it's very important to us that the administrator be truly independent. And we've consulted with numerous national experts who say that's standard. You would never appoint cardinal law to administer the Boston Archdiocese claim settlement process because nobody would use it. Nobody would trust it. And certainly it can't be the AG that is going to be settling claims with victims who think that the state is or know that the state is the source of the harm, and that John is the representative of the state. It just doesn't work. It has to be separated from the AG. And I think very simple tweak in the bill would be that the Attorney General and the victims would agree on who the administrator was, because who it is going to be very, very important. As I said, somebody truly independent, somebody viewed as wise, fair, prudent, and very experienced, and who's probably had a lot of experience at discerning what's nonsense and what's not. You know, what's fair and what's not.
So if I may, I want to continue to sharpen the edge here.
Yes.
So on a separation argument within the state, we have a separation of time because we're going back to, it had been 1980, now it's just at any time. So there's a separation of time. There's also a separation of department. The AG's office is fundamentally different than the YDC in terms of their mission and their personnel.
Yes.
And so one could argue that there is separation, but I think you're saying that it's inadequate.
I am. It's inadequate. I do understand the separation and so forth, but my clients don't. They see it as all one state, and they think, well, that's the lawyer for the state. Isn't he obliged to get the best deal for the state in every case? Well, that's a good question. I think he is under the rules of professional conduct, and if it's not separated from him, they're not going to trust the result, so they won't participate.
So I want to let you know, I know that I'm not being fair to you, and so the next time we come up, you're going to go first. We're going to hear 103, and then you're going to go first, okay?
I'm not sure I want that. Thank
and,
you, though.
and we'll fully respect your time. I'm just pounding towards a 12:45, and you got point 3.
Point 3 is we don't want to strip the victims of choices unduly, and what this bill still does is say that you have to waive your judicial rights as a price of admission to this process. And we don't want to do that. You're not going to get people to do that who will say, all right, I give up my right to sue. Now I enter the process. I have no idea. First, I'm not even sure the administrator is independent. Second, I have no idea what the award will be, or even if I'll get an award. And you're asking me to waive my only leverage before I enter the process? That's not going to work. They're not going to do that, and they shouldn't be forced to do that. They should be required to waive it once they are aware of the award and they decide to take it and issue a release to the state for all claims.
So as long as I'm on record of being unfair to you,
Okay.
I'd like to take like 30 seconds of your remaining time and give it to the Attorney General, either to him or Attorney Ramsey, to just respond, come up to and respond to the issue that is being presented, that we are, in this bill, denying standard judicial rights, expected judicial rights, whatever the right term is.
So the way, Jennifer Ramsey, for the record, for the way that this bill is structured and the current recommendations to you still include that the claimant would need to select into the process and would waive the right to continue to pursue litigation in order to choose to participate instead in this alternative resolution process. And that would happen at the beginning. The participation in the process is entirely voluntary. So if a victim wishes to pursue litigation instead of this process, that is still an option for them.
And it's my understanding that opting for acceptance of the process and not additional litigation, that's kind of normal in an arbitration environment? Or is that just a bad analogy?
No, that's a good analogy. And in fact, we have included some references to the arbitration statute for that reason. It is important not for this process to just be a waste of state resources for a claimant to go through it, get to the end, decide they don't like the result, and then proceed on with litigation.
All right, thank you. So please continue. And
There may be a number of ways to address it. What we want to make sure is that our claimants are putting their best foot forward and not waiving what may be their only chance at some kind of recompense for the suffering they've endured. It's a big risk for them to enter a process about which they have no idea what the result will be. Maybe as we develop the matrix, maybe as we have more security about who the administrator is and whether or not they're going to have a level of trust in the administrator and in the matrix and in the process, perhaps we could talk more about that, and we will continue talking more. Can I have one more point before I quit? I want to address, Justice Lynn, of course, had many very cogent comments, but there was one in particular, and I think everybody here would probably take some comfort in knowing it. It goes back to cooperation with the criminal case. I, of course, applaud what the Attorney General is doing with the criminal investigation. It's long overdue. I will say that the reason the criminal investigation began is because my co-counsel, Russ Riley, brought his first client, David Meehan, in to meet with Gordon MacDonald before anything else happened, and said, Gordon, my guy is credible and truthful, and he's telling you that terrible things happened at YDC, and it was widespread, and there were a lot of people involved, and a lot of victims, not just him. So what we have done ever since then, and of course Gordon, to his credit, took it and ran with it. Gordon, obviously someone I have tremendous respect for, my partner for 17 years, a guy with tremendous integrity, and I think he's done the state a great service by opening this up for public viewing and ensuring that it will never happen again. So much to learn here. But what we have done ever since, and we have 500 clients now, we have asked each one of our clients after we do the initial interview with them and find out what happened, we ask them all to go to the state police and be interviewed by the state police. And we don't require them, we don't make them, because we want victims to have options. Not a single one has refused us. Every one of our clients has been interviewed by the state police. Now, we don't have access to those interviews because the criminal and the civil processes are totally separate. And Jen Ramsey doesn't have access to those interviews. Nobody does right now. But I want you to know that that's part of our vetting process, and it's also a testament to how much we support the state's efforts in that criminal investigation. Every one of our folks has been interviewed by the state police. It also offers a layer of extra protection because, of course, if you're not candid with the state police, there are all kinds of legal consequences. So you better be right, and you better be telling the truth. And we tell them all that, and they know what the risks are, and not a single one of us has refused us. They've all been interviewed by the state police. I'll leave it with that.
So let me ask you a question. We would like to continue this conversation on the 24th of February. We'll probably start this hearing at like 10:45 at 11 o'clock. That we're going to hear 103 first, and you'll lead off. What I'm going to ask you is that enough time for you to think that you and the AG office can get to the point where we don't need to talk about the things that you agree on, but the things where you have not come into agreement, we really could use a very precise, sharp, to the point description of that position versus this position,
Okay.
so that we know what sort of issue that we need to decide on.
Yes, I appreciate that, and that date would be fine. School vacation is the next week, and I'm hoping to be in Florida with my 3 youngest. So the timing's good for me, too.
I'm hoping to go with you. So and that timeline's okay? Okay. So with that, is there anyone else in the room that had something they wanted to say today and has not? Is there anyone on the panel that still has something to say that they have not? Okay. So with that, I'm going to thank you for your time.
Thank you,
and
Representative Edwards.
and I hope you accept my apology for cutting you short.
No problem. Thank
But
you.
we're going to close the hearing on HB 1677. And with that, I'm going to open the hearing on HB 103, and we're going to go into recess on HB 103 until 24 February at 10 a.m. in this room. Meeting's closed. I did not think it was going to take this, but I having done it, I think it needed to be this. So Pat, I just realized what we did not do. We did not take Kathy Rogers' comments and put them into the record today. Because